How you guys doing today? It's Anthony Gangi. Welcome to another episode of Tier Talk. Guys, if the cases that we don't cover just get crazier and crazier, I'm covering another case here out of Pennsylvania. This was recommended to me. It looks like it's coming from Duncannon, Pennsylvania. It involves an 11-year-old boy named Clayton Dietz. 11-year-old boy shoots his father in bed in the middle of the night. Now they want to charge him as an adult. This case has a lot of questions. So I'm going to kind of take the journey with you. This is all the details I got so far. I think I'll definitely have some follow-up discussions on this case, especially when it comes to juveniles in court. If he is tried as an adult, how's that going to affect him as a juvenile? But this is an 11-year-old kid. Kills his father. And I believe he was adopted. I got two videos. Let me show you first these two videos. It's coming from local news. I think this story should get more attention.
I'm Alicia Richards. So glad you're with us. Tonight, we begin with new information in the case of an 11-year-old Perry County boy accused of killing his father.
Police say the boy, Clayton Dietz, shot and killed his father, Douglas Dietz, inside their home on South Market Street in Duncannon. We have team coverage, and we begin with Sarah Wilson, who is live in Duncannon. Sarah?
Alicia, Dennis, good evening to you. Just hours before this all happened, the boy's mother posted on Facebook wishing her 11-year-old son happy birthday. Court documents show that the family celebrated around midnight, but around 3 a.m., tragedy would hit. Police say what began as a birthday celebration for 11-year-old Clayton Dietz ended hours later with his father, 42-year-old Douglas Dietz, dead, allegedly shot by the boy himself.
This is a very sad situation, and it's a situation that will take quite some time to work its way through the court system.
Clayton was charged with criminal homicide on his 11th birthday, just hours after celebrating with his parents at midnight. According to court documents, the shooting happened around 3 a.m. Tuesday. Clayton's mother, Jillian Dietz, told police that she and her husband Douglas had gone to bed. She woke up to a, quote, bang. That's when she turned on her bedroom lights and found Clayton standing in the closet. She told police that her son said, quote, he's dead. But there is plenty about this case we still do not know. No comment. Perry County District Attorney Clay Maris didn't fill in any of those blanks today. But according to court documents, Clayton's mom says he was upset when he was told to go to bed and had his Nintendo Switch taken away. He admitted to police that he got the key to the gun from his father's drawer. And that is when police say the boy told them that he went inside that safe looking for his Nintendo Switch and instead got the gun, took it out, and allegedly shot his father in the head.
When a juvenile is charged with murder, they automatically begin as charged as an adult.
Which is the case for Clayton right now, but that could change through what's called decertification.
And decertification is a filing where the defense tries to say the individual should be prosecuted in the juvenile justice system for a variety of reasons.
That's up to a judge, and whatever they decide will make a huge difference.
The big difference is that the adult court system, if someone is convicted of first-degree murder, they have a much longer sentence. Because this is a juvenile, the juvenile does not automatically get life without the possibility of parole. That law changed a number of years ago.
And again, that will be up to a judge. The attorney you just heard from is not Clayton's attorney, but he tells me that he has tried other cases like this in the past. He says it is possible more charges could be coming in a case like this. That does include the possibility of first-degree murder. We're live in Duncannon. Sarah Wilson, ABC 27 News.
Sarah, thank you.
Hi, I'm Eric Finkenbinder from ABC 27, and we're excited to...
So before we get to the second video, I mean, the 11-year-old said he's dead. So if the mother said that he said that, then does the 11-year-old know the consequences of his actions? That's interesting. And also, why would the 11-year-old check the safe where they hide, where the gun is secured? Why would the 11-year-old think the Nintendo Switch was there? Either he had no idea what was in the safe to begin with, and maybe that's where he thought daddy secures his stuff, or maybe the kid's developing an alibi, saying, "Hey, I didn't want to get the gun, but the gun was there." Or did they hide the Nintendo Switch in the safe before? Like, why would the kid automatically think that the Nintendo Switch was in the safe where the weapon is? I mean, I would hope to think that if we did take something from the child, you would know that the child would go to look for it. So hopefully we didn't put that anywhere near where the weapon would be, if that was the case. I mean, Pennsylvania, and we'll go over it, doesn't have the same type of storage of gun laws that you see in other states. I want to show you guys one more video. Because I know one of the questions I had here when it came to the storing of the gun was the gun stored with the ammo? Because if so, that's a no-no, at least in some states. Was the gun had the lock on? That's supposed to be done in some states, but I don't think Pennsylvania has those same types of laws. I looked it up. I'd love your thoughts on it. But let me show you one more video.
David Stuckey is not just a family friend. The Dietz family considers him as an uncle to the 11-year-old Clayton William Dietz, who is accused of shooting and killing his own father just 2 days ago.
I would be honored to be noted as half the man or father that Doug was.
David Stuckey had only known Douglas since he met his wife, Stuckey's close childhood friend, Jill.
I couldn't even begin to paint you the picture of Jill right now. In the matter of a millisecond, her entire world changed.
The Dietz family, Jill, Doug, and Clayton, would virtually call Stuckey 2 or 3 times a week as he is studying in Mexico right now.
My title to Clayton is Uncle David. If you ask him who I am, he will tell you I am Uncle David. We have a unique bond.
Stuckey studies clinical mental health and tells me Clayton deals with autism, which escalated quickly in 2025.
I will say it's remarkable, the leap in the red flags that we noted to the extreme of this event.
Stuckey says at Douglas and Jill's request, he drafted a letter to the Susquehanna School District asking to move Clayton to a behavioral education center.
In the letter, I was speaking to the tune of the school violence that we're seeing, and that some of these subtle behaviors could eventually lead to a situation.
But the family, including Stuckey, says despite all specialized education, they never saw this coming.
The two loved each other. They had a great father-son bond. It's picturesque. It's shocking. It's so cliche to say. It's very close to home. It's personal now for me.
Now, we did file a right-to-know request with the Susquehanna School District about those communications between the parents and the school district. Those responses can take time, but Pennsylvania state law says they have up to 30 days to get back to us. We'll keep you updated both on air and online at WGAL.com when we get those responses. In Duncannon, AJ Sisson, News 8.
So I know we see what he's saying, and now the child could have autism, requesting for him to be in some behavioral classes at the school, and red flags. I mean, really, with the red flags? I mean, who would think that 11-year-old is going to pull a gun out and kill their father or adopted father? So that's just tough to get your hands around. I just can't wrap my hands around why he would think the Nintendo Switch is in that safe. That's interesting. So I got some stuff I want to discuss real quick. So in the early morning hours of January 13, 2026, a quiet home in Duncannon, Pennsylvania became the scene of an almost unthinkable tragedy. Jillian Dietz was jarred awake by a loud boom and the acrid scent of what she thought smelled like fireworks. She reached over to nudge her husband, 42-year-old Douglas Dietz, but he was unresponsive. In the darkness, she heard a soft dripping sound. When she flicked on the light, she was horrified to see blood pooling. Douglas had been shot in the head as he lay in bed. Moments later, their 11-year-old son, Clayton, appeared in the doorway of the adjoining closet that connected his bedroom to theirs. "Daddy's dead," the boy announced quietly. And then, in a chilling confession heard by responding officers, Clayton told his mother, "I killed Daddy." I'm wondering, I can't picture an 11-year-old kid shooting from a distance because I don't know how the bed would be positioned, but there'd be a chance he can hit the mom or it could go through the dad and hit the mom. So I'm wondering if this was up close. I mean, they said she smelled the acrid scent. So I'm wondering if this was up close and he shot him. There's intent there. Can an 11-year-old just turned 11? Pennsylvania State Police investigators on the scene in Duncannon after the early morning shooting on January 13, 2026. Sorry, guys. Pennsylvania State Police investigators on the scene in Duncannon after the early morning shooting on January 13, 2026. Officers responding around 3:20 a.m. to the South Market Street home found Douglas Dietz deceased from a gunshot wound to the head, lying in the bed he shared with his wife. According to an affidavit later obtained by local reporters, the night of the incident had begun in joyful celebration. January 13th was Clayton's birthday. The family had stayed up past midnight singing happy birthday to the boy before turning in for the night. Clayton told investigators he had a good day with his parents, but when Douglas told his son it was time to go to bed and confiscated his Nintendo Switch video game console, Clayton got mad at him. The documents say, and still harboring anger, the 11-year-old decided to retrieve his beloved game system, a decision that would have devastating consequences. Could you imagine a mom that has to still live in the house, sleep in the bed? According to the police affidavit, Clayton said he went looking for the Nintendo Switch that had been taken from him, thinking it might be hidden in his parents' bedroom safe. In the dark early hours of his birthday, the boy found a key in the father's dresser drawer that unlocked the gun safe, the documents allege. Inside, instead of his game console, Clayton discovered one of his father's firearms, a revolver. The 11-year-old removed the handgun, loaded it with bullets, and walked to his sleeping father's side of the bed. All right, so maybe there weren't bullets in the gun at the time. Looks like he loaded it with bullets. I mean, usually I'm familiar with laws that the gun has to be in safe, locked, and the bullets have to be stored in another area. But it looks like maybe the bullets were accessible and the gun was unlocked. But again, Pennsylvania, and we'll go over it, doesn't have these type of gun storage laws that I'm familiar with. The 11-year-old removed the handgun, loaded with bullets, and walked to his sleeping father's side of the bed, standing over Douglas in the darkness. He did do it directly up close. Clayton pulled back the gun's hammer and pulled the trigger, shooting his father in the head at point-blank range. The blast was the boom that startled Jillian awake. When state troopers later asked Clayton what he thought would happen when he fired the gun, the child replied that he was mad and he had not thought about that. In fact, when first questioned about the morning's events, Clayton told police simply, "I shot somebody," and admitted he had someone in mind whom he was going to shoot, whom he identified as his father. Those matter-of-fact words coming from a boy who had just turned 11 stunned even veteran officers. Plus, when he told his mom, "I shot Dad." Shot Dad. Where is it? Daddy's dead. I killed Daddy. It says it right there. I killed Daddy. Does the 11-year-old really know what he's doing? I think so. The case has also raised broader questions about firearm storage inside homes with children. Pennsylvania does not currently have any statewide laws requiring firearms to be stored in a particular way or imposing criminal penalties when a child gains unauthorized access to a gun. While gun dealers must provide a locking device with handgun transfers, owners are not legally required to use it. Some Pennsylvania cities like Philadelphia have local ordinances requiring firearms in homes with minors to be secured, but most of the state has no such requirement. There have been legislative proposals to establish safe storage laws, but none have passed as of early 2026. Investigators have not alleged any wrongdoing related to gun storage in the Dietz case, and no additional charges have been announced. Still, the case underscores how quickly access can turn a moment of anger into irreversible harm. They need to relook at that law. They do. They need to look at that. A family and community shaken. The Dietz family background made the incident all the more confounding to those who knew them. Clayton William Dietz was adopted by Douglas and Jillian Dietz in 2018, becoming their only child. Friends say the couple were devoted, loving parents. David, Uncle David Stuckey, that's who you saw in the news clipping. A close family friend whom Clayton regarded as an uncle described Douglas as a model father and said father and son shared a great bond. The two loved each other. They had a great father-son bond. It's picturesque, Stuckey said, emphasizing that nothing in their relationship suggested inevitable violence. Neighbors, too, were astonished. They're very kind. They kept to themselves and just seemed pretty nice. I didn't expect this, said Jesse Welding, a lifelong Duncannon resident who lived down the road. In a small town where serious crime is rare, the idea of an 11-year-old killing his dad left the community reeling. The local school district, aware that Clayton was a fifth grader in the Susquehanna School District, issued a statement offering sympathy and counseling resources to help students process this tragedy. As friends and officials scrambled to understand why Clayton might have done something so extreme, some details emerged suggesting the boy had been struggling with behavioral and emotional challenges. According to Stuckey, Clayton has autism spectrum disorder, and his behaviors escalated quickly during 2025. Stuckey, who has a background in psychology, noted remarkable red flags in Clayton's behavior last year, though nothing that remotely foreshadowed this level of violence. In fact, at Douglas and Jillian's request, Stuckey had helped advocate for Clayton's special needs at school. Just 3 months before the shooting in October 2025, Stuckey wrote a letter to the Susquehanna School District, urging that Clayton be moved to a specialized behavioral education program due to rising concerns. WGAL News 8 obtained that letter dated October 9, 2025, which detailed several disturbing incidents at school. So in June of 2025, 10-year-old Clayton had made an inappropriate sexual remark to a male classmate. Then October 2025, he directed a similar sexually inappropriate comment towards a female student. The letter documented how often Clayton parents met with school officials and pleaded for more support and supervision for their son. Despite some specialized education services and interventions being put in place, Stuckey and the Dietz family were growing alarmed at the subtle behaviors Clayton was exhibiting, warning signs that, as Stuckey phrased it, could eventually lead to a situation if left unaddressed. No one imagined that situation would be the killing of Douglas Dietz. We never saw this coming. Stuckey admitted, still in shock, that the sweet little boy he knew turned violent. Notably, when police took Clayton into custody on January 13th, they observed that the boy had a large bruise above his left eye and a cut on his bottom lip. How Clayton got those injuries remains unclear from public records. There is no indication of any ongoing physical abuse in the household. By all accounts, Douglas was a loving father and Jillian a caring mother. It's possible the bruise was unrelated, for instance, an injury from a playground incident or an outburst, or it could have resulted from some struggle or tantrum the night of the shooting. Authorities have not commented on it further, but the detail raises troubling questions about what might have transpired in the hours leading up to the shooting. Was there a physical confrontation when Douglas confiscated the Nintendo Switch or put Clayton to bed? Or did Clayton perhaps harm himself in distress after realizing what he'd done? Those details are not yet known. What is known is that an ordinary parent-child conflict, a bedtime argument, and lost video game privileges somehow spiraled into deadly violence. The sheer incomprehensibility of an 11-year-old executing his sleeping father has left family, friends, and neighbors grasping for answers. As Stuckey put it, reflecting on Jillian's heartbreak, in a matter of milliseconds, her entire world changed. Now, will he be charged as an adult? Pennsylvania's harsh juvenile crime law. I use the word harsh in quotations. In the aftermath of the shooting, Pennsylvania State Police moved quickly to file charges. In a decision that has drawn widespread attention, Clayton Dietz, just 11 years old, was charged with criminal homicide as an adult. He was arraigned on the homicide charges and, as is standard in Pennsylvania for such offenses, denied bail, meaning he must remain in custody pending trial. Clayton is currently being held at the Perry County Prison, a county jail rather than a juvenile detention facility. A preliminary hearing is scheduled for Wednesday, January 22nd, 2026 at the prison, where a judge will review the evidence and determine whether the case should proceed to trial. The decision to charge a child of 11 in adult court has shocked many observers. However, Pennsylvania law provides prosecutors little choice in the matter. If a juvenile is accused of homicide in Pennsylvania, regardless of age, state law requires that the case be initiated in adult criminal court. This rule is a legacy of tough-on-crime laws from the 1990s. Pennsylvania is one of only a handful of states with no statutory minimum age limit for trying a child as an adult, and the state statutes mandate adult charges for murder at any age. In fact, the law explicitly excludes homicide from juvenile court jurisdictions, funneling even grade school age suspects into the adult system by default. Cumberland County District Attorney Sean McCormick, not involved in this case but familiar with the statutes, remarked that in Pennsylvania, if an offender is as young as 11 and commits a killing, you have no choice. You have to charge them as an adult. McCormack, a veteran prosecutor, confessed he had never dealt with a case with someone so young before, underscoring how extraordinary Clayton's situation is. What's your thoughts on that? You know, is that child 11 kills someone, should they automatically be charged as an adult automatically? So under these laws, Clayton joins a very short list of extremely young defendants forced into Pennsylvania's adult court. The last time the state saw an 11-year-old charged with homicide was the infamous Jordan Brown case in 2009. Jordan was also 11 when accused of shooting his father's pregnant fiancée. He too was automatically charged as an adult and initially faced a possible mandatory life without parole sentence. Jordan Brown's case was eventually transferred to juvenile court on appeal, and his conviction was later overturned. The Dietz case has inevitably drawn comparisons and reignited debate about Pennsylvania's approach to juvenile crime. So we got reform possible gun storage laws, or just gun laws in general, and now this part of the juvenile justice, or charging a juvenile and adult crime automatically. I mean, whether he deserves it or not, I think the question on the table is that a law that could just be generally applied to anybody who commits a homicide, including juveniles or young children. Let's see, where was I? Dietz case has heavily drawn comparisons and reignited debate about Pennsylvania's approach to juvenile crime. Legal experts point out that these automatic adult charge laws were born in the super predator era of the mid-1990s, when politicians reacted to fears of violent youth crime by making it easier to prosecute kids as adults. In 1995, Pennsylvania's legislature passed a direct file statute, Act 33, which requires that teens 15 to 17 be tried as adults for certain felonies, especially if a weapon was used. And it made murder charges exempt from juvenile court entirely. This means even a child well below the teenage years, Pennsylvania has no statutory minimum age for criminal prosecution, can be charged, jailed, and tried as an adult if accused of homicide. Clayton Dietz, who had only just turned 11, is thus subject to a process designed for fully grown offenders. This is tough because you got someone that committed a crime, looks like he knew what he was doing, but he's also 11. So there should maybe some conflict in the comments here, but it's definitely a discussion that I think would benefit our community, see what people think. But remember, respectfully, because this could be something that could be passionate on both sides, but we want to try to see maybe there's something in the middle, something on that's not always at the extremes, but rather somewhere here. Defense attorneys and juvenile justice advocates are likely to mount a vigorous effort to decertify or transfer Clayton's case back to juvenile court, despite the initial adult charge. Pennsylvania law does provide a mechanism for this. After the filing in adult court, the defense can request a decertification hearing where a common pleas judge will consider whether the case should be moved to juvenile court, where the focus is on rehabilitation rather than punishment. Separate from questions of guilt or innocence, courts may also be required to assess whether a child this young is legally competent to understand proceedings and assist in their own defense, a threshold issue that could shape how the case moves forward. At a decertification hearing, the judge weighs factors like the protection of the public, the nature of the offense, and the child's amenability to treatment or rehabilitation in the juvenile system. D.A. McCormick explained that essentially the court must balance society protection against the juvenile's capacity to be reformed. What you're looking for is a couple of things. One, protection of society balanced against the juvenile's ability to be rehabilitated. There's a lot of factors that the court considers in deciding whether to keep a young defendant in adult court. In Clayton's case, those factors will likely include his age, extremely young, his mental health, the reported autism diagnosis, his family support system, and the circumstances of the crime. Was it calculated or a sudden outburst by a child who didn't understand the permanence of death? If Clayton's lawyers can persuade a judge that he belongs in the juvenile system, he would be tried in juvenile court for delinquency, and any disposition would focus on treatment and education, with the maximum confinement being custody in a juvenile facility until age 21. On the other hand, if the case remains in adult court, the stakes are far higher for the child. And that's a good question to at age 11. Would he understand the permanency of death? I mean, again, he's autistic. I mean, does that affect that? Because I know, that's one thing as kids, when they're young, they don't understand how permanent death can be. But then eventually as they get older, they start to understand that. I think by age 11, you definitely understand it, but he's also autistic. So yes, he knows what he did, but does he understand the permanence of that? So that's another perspective. So yes, he may know he killed his daddy. Daddy's dead, but what does dead mean to you? What an 11-year-old faces, possible charges and penalties. At present, Clayton W. Dietz is formally charged with criminal homicide, a broad charge under Pennsylvania law that encompasses various degrees of murder as well as manslaughter. Authorities have not publicly specified which degree of homicide they intend to prove. That would typically be determined as the case progresses. For example, at trial, a jury could be instructed on first-degree murder versus lesser degrees. Given the allegations in the affidavit, prosecutors could pursue a charge of first-degree murder, which in Pennsylvania means an intentional, willful killing. The court document suggests Clayton formed an intent to shoot his father. He had someone in mind and went to retrieve a gun and carried out the act deliberately, albeit in a fit of anger. If first-degree murder is proven in adult court, Pennsylvania law ordinarily mandates life imprisonment without parole. However, because Clayton is a juvenile, the U.S. Supreme Court rulings, Miller versus Alabama and others, prohibit automatic life without parole for minors as unconstitutional, cruel, and unusual punishment. Pennsylvania had to revise its statutes accordingly. Now a child convicted of first-degree murder as an adult in Pennsylvania faces a minimum sentence of 25 years to life in prison if the child was under 15 at the time of the crime. In other words, Clayton, at 11, would technically be eligible to seek parole only after serving 25 years, meaning he would be well into middle age by the time he'd have a chance at release. The court could still impose a longer minimum or even a discretionary life without parole term if it finds that circumstances exceptionally heinous. State law allows life without parole for juveniles in rare cases, but there is now a strong presumption against it. Even if convicted in adult court, Clayton would not immediately enter a standard adult prison population. Pennsylvania, like most states, would be required to house a juvenile offender separately from adult inmates, often in specialized or transitional facilities, until reaching an appropriate age. Still, the long-term trajectory would place him under the authority of the adult correctional system, a reality that carries profound developmental and psychological implications. And guys, I've done videos on that, so you could check out on my library of videos, juveniles doing adult time. Put Tier Talk juveniles doing adult time, etc. You'll see I've done videos on that. Let's see. Where was I? All right. If the court or a jury were to find Clayton guilty of a lesser homicide charge, such as third-degree murder, an intentional act done with malice but not premeditated, or manslaughter, the penalties would be lower than for first degree, though still severe. Third-degree murder in Pennsylvania is a first-degree felony, normally punishable by up to 40 years in prison. Voluntary manslaughter can carry up to 20 years. It's far too early to predict how prosecutors will classify the crime or if any plea bargain might be considered, but the bottom line is that in an adult court, an 11-year-old faces the possibility of decades behind bars. The contrast with the juvenile court outcome is stark. If Clayton's case is moved to juvenile court, he would not be convicted of a felony in the traditional sense, but rather adjudicated delinquent of an offense. The juvenile system aim would be rehabilitation, so intensive counseling, education, and mental health treatment in a youth facility. Pennsylvania juvenile's jurisdiction ends at age 21, so even for the most serious offenses, a juvenile disposition cannot extend beyond a defendant's 21st birthday. So in theory, that means Clayton could only be confined for at most 10 years until 2035 if treated as a juvenile, and he would emerge with no adult criminal conviction on his record. This huge disparity in potential outcomes, 10 years in a juvenile program versus a lifetime in prison, underscores the high stakes of the upcoming legal proceedings. It also fuels a debate over whether a child so young should ever be subjected to the adult criminal system. It's funny because this case kind of reminds me a little bit of the Jesse Mack Butler case, which we covered a lot. Even though he should have been given a harsher sentence, it went towards the youthful offender program. But if you're not familiar with that case, you should look at the case. I've done a few videos on that. I have a playlist on that because a lot of this seems to be very similar but definitely representing two different perspectives. And then there was another case, I think it's out of Ohio, I covered, Amory Jones, where the girl was 5. She was beaten, sexually assaulted, scalped. It's a horrible story. And the people involved were kids, a 10-year-old, a 9-year-old, and an 8-year-old. And I think the 10-year-old and 9-year-old are being charged. So they're going to see if they're competent to defend themselves. You know how that works. And then I think the 8-year-old, I don't know what they're doing with the 8-year-old. But that's a process. But they're also a little bit more private with it because they're juveniles, technically. But I did do a couple videos on that. So if you get a chance, check those out. But, this is good because, we learn. So, that was Pennsylvania, and the other two cases are in Ohio. Jesse McButler, I think, is Ohio, and so is Amory Jones. So how young is too young? So news of Clayton's arrest and adult homicide charge spread quickly and has prompted intense discussions in the public and legal community. That's what I saw. So media headlines across the country highlighted the astonishing age of the suspect, an 11-year-old charged with killing his own father. The case has raised painful questions. How could a child in elementary school acquire a deadly weapon and calmly shoot his parents? What could drive such extreme behavior? A video game dispute escalating into patricide? And perhaps most urgently, what is the appropriate way for the justice system to respond? Neighbors and community members continue to express shock and sadness. For many, the Dietz family tragedy is a stark reminder that serious domestic violence can erupt in even the most unlikely places. Not really ever this close, you hear about it, but not right next door, said one stunned neighbor, reflecting on how unimaginable such an event was in their quiet neighborhood. The community has rallied around Jillian Dietz, who lost her husband and effectively lost her son to the justice system in one night. Local churches and counselors are offering support to those who knew the family. The Susquehanna School District, where Clayton attended, has made psychologists available for any student struggling to process the incident. Classmates of Clayton, many of them just 5th and 6th graders, are bewildered at how their peer could be involved in something like this, and teachers are carefully addressing the topic to dispel rumors and help students feel safe. I mean, imagine being Jillian right now. You lost your husband, the love of your life, and the adopted son, or your son technically, is now locked up in the justice system, and is she going to support him? Wow. What would you do? Just, wow. Among legal experts and juvenile justice advocates, Clayton's case has become part of a larger conversation about reforming Pennsylvania's law on trying kids as adults. The fact that an 11-year-old can be housed in an adult jail and face adult penalty strikes many as fundamentally problematic. But by the way, when they say housed, he's not going to be with the adults. He'll be in the jail, but he'll be separated at some level of PC or something. They're not going to put him around adults. Let's just get that out of the way. Even though he's in the jail, he's not going to be with the adults. Advocates argue that children of Clayton's age simply do not have the brain maturity or impulse control to be held to adult levels of accountability, even for grave acts like homicide. Research on adolescent brain development indicates that kids are impulsive, short-sighted, and highly malleable. Clayton's own statement to police, he admitted he was furious about his game being taken, but had not thought about the consequences of firing the gun, seemed to reinforce the notion that children do not fully comprehend the permanence of death or the legal ramifications of their actions. His case therefore tests the balance between public safety and the capacity for a child to be rehabilitated. Now, mind you, also about his competence, too. Notably, Pennsylvania's approach stands in contrast to many other states, and critics say it's overdue for change. Marcia Levick, chief legal officer of the Juvenile Law Center in Philadelphia, points out that Pennsylvania's automatic transfer and direct file laws were born of the 1990s super predator panic, a period now widely regarded as a moral panic based on flawed predictions of a coming wave of juvenile crime. The prediction of a super predator epidemic was a costly mistake. So were the juvenile laws it inspired, including Pennsylvania's automatic direct file statute. A Pittsburgh Post-Gazette editorial declared in mid-2023, calling on legislators to undo that law and allow judges more discretion in such cases. Pennsylvania is one of the few states with no statutory minimum age for adult prosecution, meaning children could end up in adult court for very serious charges. We touched on this. At extraordinary young ages. The racial disparities in the application of these laws have also been documented. A state task force found that Black youth in particular were disproportionately likely to be charged and sentenced as adults under the direct file system. In recent years, juvenile justice advocates in Pennsylvania have been pushing for reform, and in 2023, a bill, HB 1551, was introduced in the state legislature aiming to prohibit prosecuting children as adults in most circumstances and repeal the direct file statute. The ACLU of Pennsylvania and other groups support the bill, arguing that funneling kids into adult prisons has proven ineffective, failed, and cruel, with studies showing higher recidivism rates for youth tried as adults compared to those handled in juvenile courts. As of early of 2026, however, those reforms have not yet become law, meaning Clayton Dietz' case will unfold under the current legal framework. Within that framework, Clayton's defense team is likely to emphasize his youth and mental condition and argument for leniency and a transfer to juvenile court. The fact that Clayton is diagnosed with autism may play a significant role in both legal strategy and public perception. Autism spectrum disorder can involve challenges with impulse control, emotional regulation, and understanding the consequences of one's actions, especially in a child so young. Family friend David Stuckey noted that Clayton's autism-related behaviors had worsened in the year prior and that the family was actively seeking more support for him. If the case proceeds in adult court, expect the defense to request comprehensive psychological evaluations of Clayton. These evaluations could assess his competency to stand trial. Does an 11-year-old with autism even comprehend the legal proceedings? And can he assist in his defense, as well as provide insight into his mental state at the time of the shooting? Pennsylvania law will not allow an insanity defense in the traditional sense for a child's immature judgment, but such evidence could be used to argue that Clayton lacked the capacity for the specific intent required for first-degree murder, or simply to urge a judge to show mercy. On the other side, prosecutors have a delicate task. They must pursue justice for Douglas Dietz's death, a man allegedly slain in his own bed, while also grappling with the reality that the accused is a fifth grader. There's no precedent for incarcerating an 11-year-old in Pennsylvania's adult prison system in modern times, even if convicted. Clayton would likely be held in some juvenile or specialized facility until he's older. The Perry County District Attorney has been relatively circumspect in public comments so far, given Clayton's age. The DA's office did issue an initial statement confirming that a juvenile household member was in custody and that there was no danger to the public. Beyond that, officials have said little publicly, undoubtedly mindful of the sensitive and sensational nature of this case. So what's the road like ahead? As Clayton Dietz's case moves forward, it's sure to be closely watched, not only by Perry County residents, but by legal observers nationwide, by us. Can an 11-year-old be held to account as if he were an adult? This question lies at the heart of the ordeal. The coming weeks will bring the first legal steps, the January 22nd preliminary hearing, where magistrate will review the evidence of Clayton's alleged offense. Given the detailed affidavit and even Clayton's own admissions, the case will almost certainly be bound over for trial in the Court of Common Pleas. At that point, the defense is expected to file a motion to transfer the case to juvenile court. That's the decertification request. A decertification hearing would then offer the first real arena to debate Clayton's fate. Experts in child psychology, educators, and perhaps Clayton's pediatricians or therapists might testify about his capacity for change and what kind of treatments he needs. The judge could decide that keeping this child in adult court is not in the interest of justice and approve the transfer, effectively stating that society is better served by trying to rehabilitate Clayton in the juvenile system than by imposing a harsh adult punishment on a child. If, however, the judge denies transfer, Clayton would remain in adult court for the duration, facing a criminal trial by jury. Such a trial could be challenging for jurors who would have to reconcile the grievous fact of the crime with the sight of a small boy at the defense table. Imagine being the jury on that. You know, we look at these cases from a distance, and, you know, it's safe for us to try to make some decisions because, you know, we're not directly involved. But what about if you are directly involved? And then when you want to make that decision, let's say for some people that say, no, he's 11, but he knew what he did, and he's got to face the consequences of those choices. Well, what about how the mother may feel? Are we taking her into account? She just lost her husband. How is she viewing her son? I mean, you know, she still may want to try to maintain a relationship with him. She may be as tough as this may be in her son's corner, her adopted son's corner. I mean, she lost two people, technically, as we said, you know, one to death, one to possibly the criminal justice system. I could picture her, because I'm sure this is what Douglas would want, is for her to stand by Clayton. So this case has reignited long-standing ethical questions about children and criminal responsibility. One core issue is the tension between acknowledging the heinousness of the act, the deliberate killing of a parent, and recognizing the immaturity of the actor, a child who had only recently turned 11. Modern neuroscience and psychology consistently find that juveniles are different from adults in culpability. We talked about this. They're more impulsive, more susceptible to peer pressure, and less able to foresee consequences. Clayton's impulsive reaction to having his video game taken away illustrates how a child's anger can be intense but fleeting and not tempered by the broader understanding of an adult might have. The fact that, according to the affidavit, he did not plan beyond the moment of pulling the trigger, he admitted he hadn't thought about what would happen after he shot his dad, is tragically emblematic of a childish mind. Yet the result of his action was real and irreversible as any adult crime. A man lost his life. Society is thus faced with a profound dilemma. How should a just system respond when an 11-year-old commits a murder? I mean, he stood there and he admitted what he did. I shot my dad. Made no effort to hide it. He just did what he did. Pennsylvania current law answers with one word: punish. Charge them as an adult, it says, and if convicted, impose a long prison term, albeit with the possibility of parole down the line. But many ethicists, and child advocates argue that this approach fails to account for the fundamental differences of youth. International human rights standards are generally in agreement that children should be treated differently. For instance, international law forbids sentences of life imprisonment without parole for those under 18 at the time of the crime. The United States was for many years an outlier in permitting juvenile life without parole, so JLWOP. Pennsylvania, in particular, amassed one of the largest populations of juvenile lifers in the world. Court decisions in the last decade have forced some change. Hundreds of juvenile lifers in Pennsylvania have been resentenced or released due to the Supreme Court Miller and Montgomery ruling. However, the law that put them there in the first place, the direct file and automatic adult charge for certain offenses, remains on the books. The Dietz case is poised to become a touchstone in the argument for changing those laws. If an 11-year-old being held in prison and facing a life term doesn't compel lawmakers to revisit the policy, reformers ask, what will? Already the case is being cited by advocates in Harrisburg who support legislation like HB 1551 to eliminate automatic adult prosecution of children. They argue that children belong in a juvenile justice system where they can receive education and therapy geared toward their development rather than in the punitive environment of adult prisons. They also note public safety benefits rehabilitated youth. They also note public safety benefits. So you got rehabilitated youth are less likely to reoffend, whereas youth thrown into adult prisons often emerge more damaged and dangerous. At the same time, others voice concerns that excusing severe crimes due to the offender's young age could set a dangerous precedent. There is a real, if exceedingly rare, phenomenon of children committing violent acts, and the justice system struggles with how to handle it. Some victims' advocates maintain that for the most serious crimes, even those committed by preteens, the court must have the option of serious punishment, both to safeguard the community and to honor the victim's life. In Clayton's case, Douglas Dietz's family and friends are grieving an unimaginable loss. They will never again celebrate Doug's warm presence at church or hear his laughter at neighborhood cookouts. He was, by all accounts, a dedicated father and husband. The image of Doug dying in his own bed on the very day he celebrated his son's birthday is haunting. There is an understandable impulse to seek justice equal to the crime. Perry County's prosecutors may feel that the only proportionate response to a deliberate murder is a severe adult penalty, regardless of the killer's age. Indeed, in the initial aftermath, the district attorney press release and court filing showed no hesitation in pursuing the homicide charge and detaining Clayton without bail. The coming legal battle over decertification, over competency, and possibly over guilt or innocence will have to reconcile those competing perspectives. I still think we also know a little bit more about that bruise, too. Hopefully, it was that he may hurt himself on the playground. It wasn't directly related to the incident that night. As of now, Clayton Dietz awaits his January 22nd hearing in a secure section of Perry County Prison, likely kept apart from the general inmate population due to his age. His mother, Jillian, faces the agonizing reality that her child is accused of killing her spouse. She has not spoken publicly, but one can only imagine her turmoil. She is simultaneously mourning her husband and trying to support her son, who remains her child, but is now also an accused murderer. David Stuckey has indicated the family's support for Clayton, even as they are devastated by Doug's death. Jill was proactively trying to make sure that her son was held accountable, but given the treatment that he needs. Stuckey observed, reflecting the nuanced heartbreak of the situation. In one sense, Jillian Dietz has lost her whole family in a single night. The community has extended sympathy to her, understanding that she's innocent, caught in a nightmare scenario. So now the hearing on January 22nd, 2026 will likely be brief and procedural. A magistrate will confirm that Clayton understands, to the extent of an 11-year-old can, the charge against him, and the prosecution will present just enough evidence to show probable cause, likely the affidavit statements and perhaps the 911 call or police observations, to hold the case over for trial. Given the overwhelming evidence outlined in court documents, including Clayton's own statements and the physical evidence of the gun, the case will almost surely advance. After that, all eyes will be on the Perry County Court of Common Pleas. The judge there will face the monumental decision of whether to keep Clayton in the adult system or not. It is a decision that requires weighing a community's demand for accountability against the knowledge that a sixth grader's life hangs in the balance. Whatever the outcome, the case of Clayton Dietz is set to become landmark in Pennsylvania's legal history, a case that forces us to confront the most uncomfortable of truths. Children, too, are capable of deadly violence. How we choose to punish or rehabilitate them may say as much about our society as it does about the offenders themselves. Clayton's story, from the sweet birthday celebration to the deadly gunshot that shattered a family, will doubtless fuel discussion among lawmakers, judges, and citizens about how to prevent such tragedies and what justice means when the perpetrator is a child. For now, one family and community are left mourning and asking why, while an 11-year-old boy awaits the consequences of an act he cannot undo. The coming months will provide some answers in court, but the broader soul searching triggered by this case will likely persist far longer, potentially shaping reform that impact many other children in the future. That's everything I got on that case. A lot there. I didn't know Pennsylvania had that law that when you have cases of murder or whatever, they have to automatically go be charged as adults unless it can get decertified. That was interesting. And I didn't know they didn't have those type of gun storage laws. So definitely some stuff here worth revisiting. And then obviously you got the age of competency. You know, can an 11-year-old, after they've done that, really at that age be competent to defend themselves? Do they actually know what the consequences of what they've done? Like I said at the very beginning, he did say that he killed daddy, but does he know what that really means? I like how later on it said the permanence. You know, that's something that isn't that the child learns as things go. That's something that they know, you know, maybe at a very young age. But again, at 11, I do expect them to know it. But he's also autistic, so I'm not an expert in that area. So there's a lot of competing factors here. And then you got Jillian. Whole life changed that instant. No, she just wondering. I could picture her standing by her son, but just wondering how do you manage the competing and conflicting thoughts that I'm sure there's got to be anger, frustration, but somehow forgiveness and love at the same time. Hey guys, if you like the content, don't forget to buy me a cup of coffee. The link to that's in the description as well as on top of the YouTube channel. I'm definitely going to revisit this case. There's a lot to cover here, but this was requested of me. I worked on it today. Hopefully you enjoyed the content, and I'll see you soon.